to a place which is safe, which in theory is not the same place where the migrants comes from. So for this reason, it's let's say that just to make a summary, that the migrants it suffer a pretty serious situation in their country of origin, that in most of cases it's not safe, since there might be a war, there might be a famine, there might be several issues. So the international law, it's like a father, let's say. It tends to guarantee to those migrants to reach another place for doing, of course, a better life, or the development of the person, of human, for in this way, for guarantee their basic human needs and so on. Then, of course, there is the United Nations Convention on the Law of the Sea that unfortunately does not talk about place of safety. The only one article that might be relevant is, as you can read, is the Article 19, which is say that a ship can be considered prejudicial to security if, inter alia, it engaged in the unloading of people contrary to immigration or sanitary laws. So in this way, there is a kind of reference to the COVID crisis, because it's it might be interpreted as a sanitary law. So if we need to interpret literally this provision, it seems that is not allowed the let's say the disembarkment, the migration, the helping of migrants at sea when it is contrary to sanitary law. So it's a very, let's say, problematic provision, this one. And then, of course, there is the European Convention on Human Rights, which is, as everyone knows, it's a kind of human rights constitution of the European Union. There are, of course, right to life, prohibition of torture, Article 3, Article 4, prohibition of slavery. So there is a pretty long list of rights that are protected to everyone as in the territory of one of the contracting states. So of course, even the migrants, if the migrants is, let's say, it's coming to a European country, he can let's say, undertake the rights of the European Convention. He can even claim the court. Moreover, it's in all the seminars that I was, I need to say that I know very well the European Convention, since I'm working for the Oxford Reports and International Law. So my let's say daily task is to make comments on the court's judgment. And then I was, of course, studying even in a Riga Graduate School of Law, where I have the pleasure to have the former president of the European Court as a teacher. Everyone today is making speeches, online speeches, about this Article 15 of the Convention, which is the derogation in time of emergency, which it says that if a state if a states want to use, let's say, this provision, this derogation in time of emergency, in any case, there are some articles, so and in particular Article 2, 3, and 4, that are not derogable at all. So they are not derogable rights, even in time of emergency, in time of crisis, in time of distress or whatever. So right to life, it's the it seems it's a part of use, the so-called use cog, and so you cannot derogate even in time of emergency. Okay, now let's move to what the Italian let's say the Italian government has recently made, which is very alarming. In some way, it helps many researchers to better investigate the matter. So everyone knows that Italy was, of course, at least in Europe, after China, one of the hittest country of COVID-19 in the beginning. So high rates of infection, especially high rates of deaths, let's say. Now, fortunately, the situation is getting better, but in the beginning was pretty hard. One of the several problems that Italy was facing and is still facing, it's the migration flow from Libya and from Tunisia. So the migration from the Mediterranean side, where in comparison with the last year, it's 3 times more. So at the same time of trying to face the COVID situation, Italy is trying to cope with the new flow of migration of migrants from Libya and from Tunisia. So it's a very hard, a very complex scenario, since it's not very easy to make quarantine to migrants, or to apply all of these measures to migrants. This is just a background. Then recently we had as well pretty serious facts, let's say, that many migrants that were in this temporary place where they need to check all the requirements and so on, they made the COVID test, and on the meantime there were several cases of migrants that they were escaping, and then they figure out that they were infected. So it was a very big issue, since even, let's say, the Italian population, they were very worried about this fact. So let's come back to the legal part. So an executive decree, that was the interministerial decree number 150 of 7 April 2020, has established that this one is the Italian version, of course, for the entire period of the health emergency resulting from the spread of COVID-19 virus, Italian ports will lack the necessary requirements to be classified place of safety under the definition of the SAR Convention, which is the Hamburg Convention, for cases of rescue carried out by naval units. Okay. In short, the Italian government has made its own declaration saying that the Italian port are not place of safety according to the international law and the SAR Convention. The measure was justified juridically with the declaration of a state of emergency, and politically with the need to protect public health. It says that the preventive effect would be threefold. First, the avoidance of new outbreaks from potentially infected migrants. Second, prevention of further burdens on the already overloaded national health system. And third, the protection of the health of migrants themselves, whom would not have adequate access to medical care in Italy due to the current crisis. So this was the justification of the Italian government. First, of course, let's go to the third part. First, of course, there will be let's say that after this executive decree that might raise several issues, not just a mere violation of the international law framework. Of course, the first clear, let's say, consequence is a violation of the SAR Convention, since the SAR Convention does not say at all that one state might declare to be not a safe place. Another very let's say interesting let's say aspect that was raised by two scholars in an article published on Verfassung blog, which is a blog of let's say international law issues, is the one that they call the effect of unilateral determination by a state in the international law framework. So they argued, they were arguing that this decree was a ministerial. So this particularly aspect is a matter. It's more a matter of a kind of constitutional law, comparative constitutional law in the international scenario realm. So this decree was a ministerial decree. It was enacted by the executive powers according to their own administrative competences. In these cases, the decree was enacted by the transport minister in cooperation with the Ministry of Interior, Healthcare and Foreign Affairs. So what happened that being an executive decree, by being an executive decree, the decree is not subject to the usual checks and balances of other political and constitutional actors. such as, of course, the parliament. Moreover, it does not need the sign of the President of the Republic. So therefore, there is these scholars are arguing that there is a very wide discrepancy between the instrument that Italy has chosen and the very impact and the striking evidence that might emerge from the application of this decree. Since Italy's obligation to respect a principle of international law cannot be suspended by what is classified as a second level norm in the hierarchy of sources. So this aspect it's very interesting. They say that it's an executive decree from one side, but from another side, an executive decree cannot derogate to international law, since it's not a primary source of law. Let's pass to the another aspect. So another aspect is of course the violation of the European Convention on Human Rights, especially as I said, the right to life, which the court several times say to entail the right to rescue the migrants, to provide assistance, and another very alarming, let's say, violation might be the violation with the principle of non-refoulement. This part was pointed out by another scholar who wrote an article on AJ Talk, which say that the Italian decree has violated the principle of non-refoulement, which is part of the European Convention of Human Rights, but also a part of the Jus Cogens norm of the international law framework. Especially for since Italy has not even made the declaration of under Article 15 of the European Convention of Human Rights, which, as I told, tends to or better clarify that right to life, prohibition of torture, they cannot be in any case derogate. So since Italy is not even made this declaration, in any case cannot violate the right of life of migrants. So let's imagine, the non-refoulement. Non-refoulement, it means that you cannot send back migrants to their home country when they might face a risk of prosecution in their home country, which is the case in almost of the migration issues or individual cases, which was the case of Afghan or Syrian refugees. So let's take an example of Tunisia, of Egypt, or or many other countries. With this decree saying that it's not a place of safety anymore, Italy might allow the repatriation of these migrants to their home countries, such as Tunisia, Egypt, or other, let's say, fragile countries, fragile political countries. And in this case, there would be the risk of being prosecuted in their home country, since we know that Egypt or Tunisia, they have very harsh, let's say, legal framework or prosecution. So the migrants might apply. This is an extreme case, by it might apply to the European Convention of Human Rights, saying that is a right for the right to not be sent back to their home countries has been violated. So there might be a violation of principle on non-refoulement. So I don't know if I can conclude here. So I would say that the Italian decree might raise many let's say complicated consequences, both in terms of the respect of the international law framework. So in particular, SAR Convention, the United Nations Convention on the Law at the Sea, the SOLAS, and so on. At the same time, might raise a very big issue regarding the European Convention of Human Rights, which might be even more risky, let's say, for Italy, for the reason that there is a court in this case, while in the international law, the court is not clear, it's not still clear if there is a court, the enforcement, and so on. For the European Convention on Human Rights, the issue is that there is a court with quite powerful tools, such as very high, let's say, compensation, and so on. So it might be very risky, since the decree, it's not in line with many principles of the European Convention. Right to life, the principle no refoulement, the prohibition of torture. It's going against the principle of the let's say basic human needs, and so on. So, which are, by the way, the founding principle of the European Convention on Human Rights. And as I say, the last issue is is whether an executive decree might derogate to the international law principles, as the decree is made by a minister, so it's unchecked. It's unchecked. It's lack of the parliament assessment, lack of the signature of the president of the republic. It's just a decree, a ministerial decree, which of course is justified by the state of the declaration of emergency that Italy has made. But it's very problematic that this kind of decree, this kind of legal tool might derogate or violate, even worse, I mean, the international law framework. So in the end, I would say that we will see what would happen in this case, but I really suspect that nothing will happen, since this COVID-19 phase has very turned upside down all the legal systems, including the of course domestic legal system, but including the international law system. So we know about all the weaknesses about the international law system, and the COVID, let's say, the popping up of COVID scenario has put, let's say, let's highlight all the weaknesses of the international law as well, including of course all including the World Health Organization and all the international let's say bodies. So in the end, I mean, we will see what would be the post-COVID world.
Thank you, sir. Thank you so much for the presentation. And if somebody has to ask a question, please do it as quick as possible. Okay, so I guess we don't have any question as such. If anybody goes through the material and has a question later, they can, I guess, email it to you, sir, and ask them. Is that okay?
It's fine. It's great. It's great.
Okay. So thank you so much, sir, for taking time out for us, and we were very happy to hear from you.
No, thank you for everyone.
Yeah, Manya.
Of you that for.
Okay, thank you, sir. Manya, you'll get the email IDs later. Whoever wants the email ID, we'll send it to you later, and you can just email sir any question you have. Thank you so much, sir, once again.
Thank you.
So we take a 2-minute we take a 2-minute break. Okay, so no, we have ma'am already here. So guys, we directly move on to the second session for today. The second session will be taken up by Jasmine ma'am. Ma'am, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, ma'am. So just
can you see me as well?
Yes, ma'am. Let me just give your introduction and then you may take over, right?
Thank you.
So for the second session, we have Jasmine Lilian Diab, ma'am. She is research associate at the Global Health Institute at American University of Beirut, Lebanon. And today she is going to discuss on the introduction of international migration and refugee law with us. Thank you for taking out the time, ma'am. And over to you.
Thank you. Thank you so much. I'd like to apologize to everyone that I did not make it to the session in the morning. We seem to have a little bit of a time conflict situation with the time difference, but it worked out in the end. So I'm going to be giving a talk on migration and refugee law and the impact COVID has had on this budding discipline of international law. Migration and refugee law were interpreted to be quite similar and overlapping in many capacities, but of course in recent years, migration has such a large scope that refugee law was insistently, of course, isolated from this and is a growing legal framework on its own. So I will begin with refugee law, give you as much of a brief introduction as possible within the 50 minutes that we have. I will then move on to its connection to immigration law, and then we will discuss the Global Compact for Migration, which currently stands as one of the most comprehensive intergovernmental agreement governing migration and the movement of people. We will, of course, wrap up with its link and its impact, the impact of COVID upon these two branches of the law. And I will be happy to take as many questions as we can take. So to start off first, refugee law is indeed a branch of international law, and it deals with the rights and duties of states and what these rights and duties are vis-a-vis refugees, and of course, asylum seekers. There are different opinions among international law scholars as to the difference between the relationship of refugee law and international human rights law and humanitarian law, but this is a entirely separate subject. Unfortunately, we don't have the time to address this. However, we are very clear on the fact that within the international human rights law framework and humanitarian law, there are legal mechanisms and frameworks that assist one to understand how to manage a refugee situation, how to interact with refugees, what their rights and obligations are in that regard, etc. So the discussion forms part of a larger debate on the fragmentation of international law. As we know, international law is a discipline. I'm sure in the classes that you've been taking earlier this week and earlier today, international law as a discipline has still struggled to become a force that is mandatable or that is implemented directly by states. International law still tends to have a suggestive nature, whereby states' actual national policies are amended to meet international law standards rather than them abiding by international law as the legal framework itself. So while some scholars conceive that each branch is a self-contained regime distinct from other branches, many people argue as well that one cannot comprehend international refugee law without multiple components of international human rights law and international humanitarian law. So basically at this stage, the proponents of this conception and this view of this holistic approach and the need to do this in the areas of refugees is a need also to include children, to include prisoners of war, to include vulnerable groups, to include other marginalized communities, to have a gender component when one discusses refugee law. Refugee law needs to encompass many legal mechanisms in order to be comprehensive and to be applied correctly. We can delve into this in the question section if you'd like, but there is a major importance that needs to be regarded towards the different factions of the refugee community and how refugee law needs to take these factions into account, whether they are marginalized gender groups, whether they are women in the society where women are stripped of their rights, whether they are young children, or whether they are even linguistic minorities and people with disabilities or the elderly. So the definition of refugee, according to the original 1951 Refugee Convention and its 1967 protocol, is still, I would say, ambiguous and interpreted differently across many states. Terms in international law are always difficult to define because of course, the input of different states, their own interests, their own understandings, and their notions of national security and of nationalism in general. So in 1988, the United Nations High Commissioner for Refugees Guideline on Refugee Children was published, specifically designed to address the needs of refugee children. This was one of the first instances whereby we fragmented a population of the refugee community and gave them their own distinct legal framework. And this is the direction that we tend to head in, especially now while we're facing a situation such as COVID-19 or an unprecedented situation that affects refugees differently. It has been actually now more recently, more clear than ever. In 1989, the UN signed an additional treaty called the Conventions on the Rights of the Child. So while giving children as an example, you can see that international law is still a body of law that is being built upon. So whether or not there are guidelines for refugee children, whether or not there is a convention on the rights of the child, all of these aspects when it comes to refugees are included. And when one discusses refugee law, one takes together all of these different treaties and brings them together in an interpretation of a specific case. So beyond this, there is a variety of definition as to who is regarded as a refugee. Usually, excuse me? Excuse me?
Sorry, ma'am, you may continue. I think the mic was automatic. Manya, please check your mic. Please, ma'am,
Okay.
continue. Sorry.
No problem. No problem. If I'm going too fast, please let me know. It's a lot of information for 50 minutes, but we're going to try and be as concise as possible. So there is a variety of definitions as to who is regarded as a refugee, and this is one of the foundational problems for refugee law. Also, this is usually defined for the purpose of a particular instrument. Like I said, different bodies of international law, different bodies of national law define refugee differently. So because of the lack of a unified definition, it's very difficult to establish this body of law. And this is why I personally call it a budding arm of international law. Still open for interpretation, still open for expansion, and still open for a debate on the definition itself. So Article 1 of the Refugee Convention, as amended by its 1967 protocol, defines a refugee as a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social or political opinion, is outside his or her nationality and is unable, owing to such fear, is unwilling to avail themselves to protection of that country. So in order to simplify, of course, fancy legal terms, a refugee on a very basic level is someone that is being persecuted or has a well-founded fear based on their race, religion, nationality, membership to a social group, and all the derivatives of what that means, or a member of a political group that is essentially afraid for their own life, and that they are unwilling to return themselves to their country of origin because of fear that the country itself cannot protect them. Moving from this, we can discuss the non-refoulement principle, which is also a principle of international law used often in refugee debates, whereby a state receiving refugees, based on this well-founded fear, this definition that we discussed, cannot return refugees to their country of origin when their lives are threatened, even if this country is not signatory to the Refugee Convention. To bring this closer to your attention and to give you a live example. So I'm from Lebanon, I live in Beirut, and Lebanon currently has the largest concentration of refugees as per population. So currently in Lebanon, between Syrian and Palestinian refugees and other minority refugee groups, the debate is anywhere between 2 million or 2.5 million refugees on the Lebanese territory, as opposed to having 4 million people in population. So you can imagine the weight of what that is on a country with already a fragile situation as is. So why are these refugees in Lebanon, and why can Lebanon technically not send them back? Lebanon is not signatory to the 1951 Convention of Refugees, nor its 1967 protocol, and doesn't have any obligations legally, quote unquote, towards these refugees. But because of the non-refoulement principle and the threat on these refugees' lives, these people cannot be returned based on this well-founded fear. A state, whether or not it is actually signatory to the convention, has this moral duty and this moral obligation in the areas of human rights. This is where we were discussing at the beginning that we cannot separate refugee law from international human rights law and international humanitarian law. Beyond this, the development of refugee problems and refugee aspects across different continents was now coming into question. So like I said, the Middle East has its own interpretation, Lebanon has its own interpretation, but other countries and other organizations, such as the Organization of African Unity Convention, for instance, defines refugee as any person compelled to leave his or her country owing to external aggression, occupation, foreign domination, or events seriously disturbing public order, and in either part, the whole of his or her country of origin or nationality. So if you see, the definition is expanding. The definition is not only expanding, the definition is being rooted in more applicable realities. So often enough in international law, we find that the definition itself is quite comprehensive and largely vague. And then once we bring it down to the ground, we bring it down to local policies and regions, we see that the definition needs to be tailored. I can take you through as well the definition of a group of Latin American governments that adopted the Cartagena Declaration, for instance, in 1984. They define a refugee or refugees as persons who flee their countries because their lives, safety, or freedom have been threatened by generalized violence, foreign aggression, internal conflicts, massive violation of human rights, or other circumstances which have seriously disturbed public order. So again, taking it back to whether or not we are able to define this body of law based on defining the actual definition of the word refugee. If you noticed, the convention itself leaves the definition largely vague and interpretable, while the Organization for African Unity and the Latin American governments make this definition more specific and applicable. So in order to move outside the notion of definitions for a moment, states around the world are grappling with a major migration crisis. And like I said, immigration law and refugee law, although they overlap, have actually deviated from each other and rendered us in a need for separate bodies of law to govern different things. Migration, like you know, can be legal, can be regular, can be irregular, can be for asylum purposes, can be for economic purposes, can be for education, can be. So the notion under which migration is governed in general is very interpretable, let alone how refugees are governed more specifically. Let's move a little bit to immigration law because I see that we have 20 minutes. So I'm sure by now we understood a little bit what the obstacles to international refugee law are. So to summarize, the definition of refugee is still very problematic. The group of conventions that are forming refugee law remain as well multiple, overlapping, and have still not centered on many definitions and application. And beyond this, refugee law has to a large extent deviated from immigration law, whereby exceptions and policies centered upon refugees and even refugees from particularly sub-minority groups within the large refugee pool are also being targeted. These people are targeted through specific policies tailored at them. We're moving as well more and more into understanding that refugees are not a homogeneous community. Not every refugee community can be treated the same, and then not every minority group within refugees can be treated the same. Let's move to immigration law. I'll give you a broad definition. We will make the link, and then we will discuss the Global Compact a bit and how it's been affected by COVID. Immigration law refers to the national statutes, regulation, and legal precedents governing immigration and into and to the deportation from the country. So strictly speaking, it is distinct from other matters such as naturalization and citizenship, although they are often conflated within immigration law. Immigration laws vary around the world, and they are based on social and political norms, the foreign interests of the country, the political agenda of the ruling party or the ruling administration. And these laws are swayed and changed by international trends, by occurrences within the country itself, and based on international conflicts. Immigration law is often adjusted, for example, whenever there is a crisis in a particular country. The Syrian crisis has prompted the international community to develop refugee and migration law extensively. Their national immigration policies across developed states have also changed in order to cater to one of the biggest refugee problems we have in the 21st century. Countries frequently maintain laws which regulate both the rights of entry and exit, as well as the internal rights, such as the duration of stay, freedom of movement, and the right to participate in commerce or government. So this, of course, if any of you has ever applied for a visa before, if any of you lives outside their country of origin, you know that you are governed by a legal framework. And this framework is juxtaposed and is interconnected with refugee law in that sense. The immigration laws of the country will govern the legal paperwork and the legal aspects that you are entitled to, your duration of stay, as well as your status within the country. National laws regarding the immigration of citizens of that country are regulated by international law. United Nations International Covenant on Civil and Political Rights mandates that all countries allow entry to their own citizens. So this, I think, is the only principle in immigration law that we, as an international community, have agreed upon. Every citizen has the right to return to their own country of origin without any obstacles or hindrance to that. If there is an obstacle or a hindrance to that, or an outward decision by the government not to let their citizens back, this enters into entirely different international legal debates. So whenever we talk about immigration, our first instinct is to discuss control measures. And unfortunately, movement around the world is not open to everyone. Borders are hardly open between a number of states that have, a long-standing solid relationship. But beyond that, migration is largely controlled. People's movements are largely controlled, and people are, unfortunately enough, not free to escape from a human rights violating situation or a situation whereby their life is threatened. They are not able to escape the situation freely. Despite the fact that we consider ourselves quite advanced in the areas of human rights and of dignity in that regard. So to control immigration, many countries set up customs, they set up entry points. Some common locations for entry points are, of course, airports, are major roads near the border where you can drive between two countries. They are at custom departments, travel documents are inspected. Some required documents are, of course, a passport or a legal travel document, an international certificate of vaccination, and all of these legal aspects and paperwork assist us in making this separation. A refugee often enough does not have a passport, does not have a birth certificate, does not have paperwork. And yet we try to place them within a very organized category in a very normalized situation. Me as a Canadian Lebanese citizen, I have both my passports. I know exactly where I'm from, and I have access to both of them through the embassies in various countries and wherever I am on the planet. Not everybody has this situation. I'm sure, again, I can give the Lebanese example because unfortunately it's a good example for honestly every migration and refugee debate on the planet at the moment. As you are well aware, in addition to the large Syrian refugee community in Lebanon, Lebanon currently houses a very large Palestinian refugee community. And this community does not have passports to a large extent, has legal documents, has travel documents, has documents that allow them to move. But a lot of countries do not accept these documents, for instance, even though the Palestinian cause is an international controversy at the moment. A lot of countries do not accept this paperwork as a means to move or to enter their states, whether this is for political reasons or, of course, in compliance with their policies on migration, which are rooted in political and foreign interests. So migration and refugees, when we put it in the eyes of the law, is still very unclear. And it is unclear because of the fact that a comprehensive notion in the areas of definition, in the areas of state interests, in the areas of what states are, who states are interested in allowing in. Often enough, major countries such as Canada, for example, will put out a call for refugees. The Prime Minister, Justin Trudeau, will tweet out in 2007 that if you are persecuted, even across the border in the United States, that Canada will welcome you and that we welcome refugees and we need you to help us build our country and to serve the community and to integrate you. And this is a policy directive. This is why the interpretation of refugee law in Canada, for example, is miles away from the interpretation of refugee law in the United States under the Trump administration, whereby his administration has been outwardly anti-immigrant, anti-Arab, anti-Muslim. Build the wall, if you remember, one of his biggest campaign slogans in the world. Major statement in the areas of refugee law, human rights law, and immigration law. It's really fascinating to see how quickly these laws can shift based on the administration serving. If you remember, under the Obama administration, immigration policies were completely different. Children born to foreign parents within the United States were allowed to stay. At the moment, this is being challenged and it is being debated in international human rights law, international immigration law, and in really international law across many different sects in general. So to a large extent, this body of law is not only interpretable, but it is still vague. And this is why the Global Compact for Migration was set into motion. The Global Compact for Migration was only drafted in 2018 in July, the 13th of July, and it was signed in the 19th of December. And it, of course, was located in New York in the United States, and it was translated across Arabic, Chinese, English, French, Russian, and Spanish. The Global Compact for Safe, Orderly, and Regular Migration, this is its complete title, is an intergovernmentally negotiated agreement prepared under the auspices, of course, of the United Nations that describes itself as covering all dimensions of international migration in a holistic and comprehensive manner. Now, this is a very bold statement, of course, based on what we just discussed in the areas of international refugee law, international migration law, and what it would mean to have a global compact for migration amid so many controversial definitions and so many different interpretations and so many state interests in that regard. So the Global Compact currently describes itself as this, and the compact was formally endorsed by the United Nations General Assembly as early as December 2018. The compact is not an international treaty, and it is non-binding under international law. So although it prides itself by being all-encompassing and that it covers all dimensions of international migration in a holistic and comprehensive manner, it remains, like other bodies of international law, non-binding. And essentially in application, this is where the problem starts. So moving from this point, as the compact is not an international treaty, it is non-binding under international law, the states that are signatory to this, the states that participated in the drafting, are not bound by it. It kind of sets a very high standard for how we'd like to operate in the areas of migration across all its factions, how we discuss asylum, how we discuss climate migrants, how we discuss climate refugees, how we discuss economic refugees, how we discuss economic migrants, how, you know, it's a very big debate and a very broad term that I think the Global Compact will need years to live up to at the moment, and years to make states live up to this in that regard. On September 19, 2016, the United Nations General Assembly unanimously adopted the New York Declaration for Refugees and Migrants. Since 2016, this has been the most recent document, the Global Compact for Migration. Building upon this, as this declaration recognized, you know, a need for more cooperation between nations to manage migration effectively, the Global Compact came in 2 years later in order to solidify this. And beyond this, the Global Compact for Migration currently has 23 objectives and commitments, which are listed in the draft of the agreement. Of course, I apologize for not having time to go through all of them, but if you'd like to ask me anything specific, please feel free. But one of the most interesting notions that I will end on about the Global Compact for Migration is that it takes the notion of national sovereignty into account. So what is the major hindrance to migration and refugee policies at the moment? It is the notion of national sovereignty. Because just like other treaties and conventions around the world that you can sign with reservation, with the excuse that it violates, you know, national security and your national sovereignty, the Global Compact gives states this luxury as well, as does the Refugee Convention, as does do a multiple of international treaties in that regard. So the Global Compact reaffirms the sovereign right of states to determine their national migration policy and their prerogative to govern migration within their jurisdiction, in conformity with international law. But what does that mean essentially? If the international legal body itself is placing your sovereignty first, then that gives you leeway to interpret international law the way you want based on your own interests, at times even violating human rights to a large extent. One of the major reasons that Lebanon, and I come back to Lebanon really because it's such a sad and good example, is not signatory to the 1951 Refugee Convention because of the crisis it already had with the Palestinian refugees. It was not in the interest of the state. And then now we are additionally burdened with another group of refugees that are really arguably very easily integratable in the areas of culture, language. They've lived across the border from us. We don't even have any language or religious barriers with these people, but it is not in the interest of the state. And because of the notion of state sovereignty in the UN principles, as a matter of fact, and then more specifically reaffirmed in every treaty, there is no obligation essentially for any state in the areas of migration. There is no obligation as to when a visa can be granted. The only obligation I would say is after an individual arrives on your territory and they can make the case that their state is unsafe, that you cannot send them back. But if you can make the case that their state is safe or that there are safe regions in their state, then you can send them back. We all know how famous the deportation flights from the United States are, addressed in the news, addressed in rhetorics and debates, addressed across their TVs and movies. It's a reality that the states justifies as A, sovereignty, B, national security. So the debate is very large. And this is why it's always interesting to discuss international migration and refugee law, because it is arguably one of the most vague aspects of international law at the moment. We will wrap up, I think, with a few minutes discussing COVID as the point of this summer school is, and very timely, I might add, because international law and the branches of international law have never been challenged more. COVID at the moment affects everyone differently, to say the least, and it affects refugees and migrant communities much more intensely. I've written on the topic and I can actually send through some articles. I believe I sent through a bibliography of these articles prior to the summer school. I hope it's been shared with you. Refugees are unequally affected by COVID. They cannot maintain basic instructions of COVID in the areas of social distancing. They're often in very crammed and unhygienic spaces. They don't have access to the sanitizers we have access to. They don't have access to the masks we have access to. They don't have access to the legal protection that we do. And in complement to this, if they are bound in their camps because of COVID, most of them often doing odd jobs and resorting to per diems per day, then they don't have access to food. They don't have access to water. They don't have access to pocket money for any emergency. And they are in already very dire situations in many states that cannot even deal with their own populations. At this moment in time, developing states around the world with refugee communities are in a very large debate with their officials, and as well in the areas of international law of how to govern these people in a crisis of the such. In Lebanon, for instance, we are embarking on a 2-week lockdown because following the explosion in Beirut, there was a hike in cases. We are embarking on a 2-week lockdown, and this is a lockdown imposed upon everyone, and of course not open for debate. Refugees are now isolated in their camps. If there is one case in a camp, you can be very sure that it's spreading. They are isolated in their camps with no access to work, no access to money, no access to any health or hygiene standards. They are living in small premises and close premises. They are probably unable as well to distance themselves from each other within the same camp itself. We have camps all over the country. And in addition to that, there is an entirely new debate emerging recently with the notion of humanitarian aid. So do you send humanitarian aid volunteers? Do you send field workers on the ground to enter these otherwise highly dangerous areas when it comes to COVID? In the areas of human rights, you can argue we have an obligation, but then this is a very exceptional situation whereby the lives of the actual volunteers and the people on the ground is also threatened. So I think that the COVID-19 pandemic has raised a lot of questions for us. It's raised a lot of questions for us about our healthcare systems, about national policy, about our understanding of what refugees and migrations encompasses in the areas of policy, rights, legal frameworks, various conventions, and how every state needs to be equipped to manage situations of disaster as well. Lebanon, again, is not a country immune to its own disasters. The explosion at the Beirut port had every refugee, every citizen, every person on this territory, whether they were here for a weekend or not, affected directly by this. And it has shown us more than ever that we don't have a national strategy to govern our citizens, let alone the most vulnerable, like refugees and migrants and our migrant domestic worker community, and a lot of minorities in the areas of course, gender, sexual orientation, young children in that regard. We are very far from this. I hope that I was able to actually summarize everything within the 40 minutes I was given. I can see that we're right on time. If anybody has any questions, I would be more than happy to answer them. Thank you so much.
Thank you, ma'am. Thank you, ma'am. First of all, I would like to say that the explosions in the Beirut has not only affected people of Lebanon, we all have been equally traumatized by it. Something like this goes across the globe. And now if somebody has a question, please unmute yourself and ask, ma'am. Zeba Hassan Khan. Ma'am, please unmute yourself and ask.
I can read one of the questions in the comments. Maybe we can start with that. Thank you for everyone that said that they enjoyed the presentation. I'm glad. Ziba Hassan Khan asks, can you please elaborate on what are the consequences when a state disregards its refugees' responsibility, especially during the time of the pandemic? So, like I said, unfortunately, when it comes to the treatment of refugees, we enter into a debate on state sovereignty and national security and the priorities of the states. Often enough in developing countries and in countries around the world that are still struggling with the pandemic, their regards for their responsibilities towards refugees is quite low. Their priority is unfortunately directed, and in some areas maybe they argue it needs to be towards their citizens prior to them even moving into the understanding of what it means to protect a refugee in such a vulnerable situation. At the moment, there are no responsibilities for states to protect refugees against COVID specifically. There are obligations among states to protect their entire standing population across COVID. I don't think that the discourse has even entered into the debate as to what it would mean specifically for states if they don't protect refugees as a community during the pandemic. At the moment, states are struggling with this, and I cannot answer the question at this time, of course. I do know that the results of course, not keeping your population and the refugee population within your borders safe is the restriction on movement. A lot of borders have been closed, a lot of states have been banned from visiting other states. And for refugees caught in the gray zone of this, they are affected more than anyone. And unfortunately, the international community is very preoccupied with finding the vaccine or protecting themselves or flattening the curve or bringing the numbers down before they even get to discussing refugees. So I would be very happy to answer this at a later time once the debate is more elaborate. Ashish Gosain, I'm so sorry if I'm not pronouncing names correctly. I would like to know if disaster situations should be accepted from protection to migrants due to the issue of carrying capacity of smaller states. Unfortunately, as well, a lot of these questions have not been answered and are very rooted in contextual situations, rooted in national policy, rooted in the relationship between the two states in question. Arguably enough, Syria and Lebanon have had a very controversial history. Lebanon is significantly smaller, has significantly less resources and less capacity and less infrastructure. And it has been argued time and time again that a country this small cannot carry on a very tangible level this many people, let alone this many refugees. Disaster situations are not the exception, actually. They are unfortunately the rule whenever we discuss refugees. So to answer your question, there are no exceptions, no. When a refugee community is coming in as a large influx to another country, principle does not make any exceptions. These people are here and they are to stay here until their home state or their home country is safe enough for them to return. So Manya Anand asks, what about the rights of internally displaced persons in addition to refugees in the present times of COVID-19? Thank you so much for attending. Thank you for enjoying the presentation. The rights of the internally displaced populations in the country differ. And this is a very big gray zone in the areas of migration and refugee law, because internally displaced persons also carry a lot of weight. You know, the definition carries a lot of weight. These people can be nationals of a country that are internally displaced within their own country. They can be refugees that are seeking asylum in a country. They can be migrants from different communities that are affected by a natural disaster, for instance, and are internally displaced. They do have rights, of course, they have rights just like everybody else. But is there a case made specifically for internally displaced people at the moment in times of COVID? No, there is not. And unfortunately, even in the areas of legal framework, internally displaced persons are very hardly ever addressed. Mostly, like I said, because internally displaced persons are often nationals of the country itself and have the rights of what it means to be a citizen, quote unquote, and are not given any special priority. Internally displaced persons, debates have ranged everywhere from granting them specific rights to placing them on the spectrum between what it means to be a refugee in your own country and a citizen, even if you have the legal paperwork. And if you refer back to the presentation, you see that migration and refugee law have essentially separated or have eventually migrated away from each other because of the notion of this paperwork and this legal aspect. If you are an internally displaced person that's a national of the country that you are an IDP in, you are arguably just as vulnerable as a refugee. And yet you are addressed differently based on the documentation that you have. So to answer your question, no, there is no additional rights at the moment for IDPs. Basil asks, can we protect internally displaced persons under rules of international law? Yes, of course. As international law is rooted in international humanitarian law for disasters that often cause IDPs to be a burden of the state. Under international human rights law, they have an obligation. Under the Covenant of Civil and Political Rights, states have an obligation. So yes, you can make a very solid argument as to why you need to protect internally displaced persons under international law.
Ma'am?
Yes.
Even I have a question.
Please.
Actually, yes, I wanted to ask, like, I've had this question for like 2 to 3 years now.
Mhm.
Seems like a perfect opportunity. So actually, I just wanted to know the countries, like you say, Lebanon is not a signatory to the 1951 Convention for the Refugees. Still, it has to take the burden of the Syrian refugees and other area, nearby refugees, whoever pours in. Same is the situation with India and Bangladesh. Recently, we have seen the influx of the Rohingya refugees. So, even I don't know about Bangladesh, but I believe it is also not the signatory of the 1951 convention, and so is not India. But the other nations, the Western nations, which are the signatory of the 1951 convention, they do not seem to take the burden as much, in spite of being the signatories. So, do you think if there is a mechanism through which we can, actually redirect these refugees to the Western nations, the burdens will somehow be lifted from us, the non-signatories, which, because we already have a lot of population of our own and we lack resources, so how can we support refugees?
I understand. I understand. India and Bangladesh have the exact same situation, I would say, as Lebanon and Syria at the moment. Like I said, even those states have obligations in the areas of international human rights law and international humanitarian law. Often enough, states just don't have the infrastructure and the capacity to take these people in. And the debate actually is as old as time. Why don't the developed nations that are underpopulated, that have a lot of resources in excess, that often enough have an aging population, that need young people, that need a labor force, that need an educated elite, that need to essentially populate their country, why don't they take this refugee burden off of other states? And there's a number of reasons for this. One of the fundamental reasons is cultural and political. So to a large extent, one of the major complaints of more conservative political parties in developed countries in the areas of migration is that these people are taking their jobs, they are diluting their culture, they are not as, let's say, Canadian or American or French or European as they'd like. Even when this population is granted citizenship after years of being there, they are still treated as immigrants. They are still called by their ethnic or religious minority. And one of the fundamental aspects as to why states are always concerned about this is their preservation of their kind of national identity and their culture. So this is A. B, the notion of national security. Often enough, Western states that are taking in, let's give the example of Arabs. I mean, taking in Arabs from the Middle East, they associate them with stereotypically violent, controversial characters, and they don't want them as part of their community. They're a misinterpretation of religion, of Islam, of their concepts of terrorism, their concepts of what it means to be an Arab or a Bangladeshi or an Indian. Their classification of the international community is one of the major hindrances of that. So juxtapose these more ideological reasons with the reason in application. So countries are not immune to uprisings, are not immune to controversy, and are not immune to being flooded with populations that they don't understand or that they can't meet the needs of. And so states often do this at a gradual pace. Canada, for instance, is regarded as a leader in immigration, but it's very selective. So every year it will take on 25,000, 30,000, 50,000. It will make sure this population is integrated and it will bring in a new group. Now, unfortunately, as you were saying, the burden is big and the burden comes fast. If you have 6 million Syrian refugees displaced all over the world, taking in 25,000 at a time is just simply not fast enough. But then the states argue themselves that they are already sharing the burden of the international community, and that because of their own sovereignty, that you cannot make them do anything at any pace that doesn't convenience you. So developed states can, in theory, take on these people, probably give them incredible lives and integrate them. But in the areas of application, this is very different. There are a lot of sensitivities in that regard. And let us not forget, of course, that the international community, at least developed states, have shifts in administration, have shifts in ideologies every few years. At the moment, migrating to the United States is almost impossible. If a Democrat is in the White House next term, you never know. Maybe if you're Bangladeshi or you're in.
I think ma'am's network connection has been lost. Just wait for 2 to 3 minutes. I think ma'am's connection has been lost. So whoever has a question, we can share the email ID. You can mail the question to her, and we'll shortly have the next session also. So let's just take a few minutes break. All right.
Hello?
Hello.
Hi, I'm so sorry. I got disconnected. Is everyone still there?
Yes, ma'am. Ma'am, I have told everybody to ask if they have any question, they can mail it to you later. I
Okay.
think there's a problem.
Yeah, there seems to be a
So
little bit of a connection problem as well where I am. I apologize.
yes, ma'am. So on the behalf of ISLR, I just want to say thank you for taking out the time. It was a lovely presentation.
Thank
And
you. I hope so. Thank you so much for the invitation. And if there are any similar events in the future, I'd be very happy to take part. Thank you so much.
thank you, ma'am. Thank you, ma'am.
Best of luck. Bye.
Thank you. Hi guys. So we start at 12:40 sharp. So you can take a 10 minutes break. Thank you.
Hello. Can you hear me?
Hello. Hi, Imran. I am getting your voice. Hello.
Should we begin, sir?
Is everything fine?
Yes, sir. We were
Okay. Okay. Sure.
All right, everyone. So for our last session, we have Dr. Gaurav Vashne. Sir is assistant professor at Aligarh Muslim University, Aligarh. And sir has specialization in insurance laws with respect to Islamic insurance. And sir has also authored a book on insurance laws and published by LexisNexis Publishers. So sir will speak the health insurance laws during the time of pandemic. I think this is the one of the most important thing that we are going to discuss. So sir, let's start. Please.
Thank you very much. It's a good noon to everyone because I think it's a time, not a morning. And hopefully this session will help you a lot with regard to the practical things that are being needed for the purposes of the health insurance in the country. As well as I will provide you an overview with regard to the insurance practices in our country and how these insurance practices has developed with regard to that. Now, everyone is familiar with regard to the quotation that a man proposes and a god disproposes, and the entire edifice of the concept of insurance is based upon this particular maxim. As the element of uncertainty in human life is one of the favorite topics for the philosophers and poets across the world in all ages. As the moment life begins until it ends, uncertainty remains the hallmark feature of every human life. We are not aware about that what will come next to us, as we are right now witnessing something which we have never thought about in our dreams of life, the COVID-19 that right now the world is suffering with regard to that. We are being remaining in under our houses for a long period of time, and still we have to wait for a period that the vaccine comes into picture. Now, coming to this insurance is as old as civilization. Insurance is as old as civilization. The term Yogashema has been the oldest term which has been used for the purposes of insurance under the Rig Veda. Under the Rig Veda, the word insurance is being derived from the Latin word security. The word insurance being derived from the word security. It is not possible for us to trace the exact date from where the practices with regard to the insurance has started in the world order. But there are various activities which give us an idea that the idea of insurance was always there with regard to in the ancient period of time. The Babylonians, the Greeks, and the Romans were the first to use insurance in the beginning of 14th century in the form of the marine insurance practices. Now moving towards the India, that how India developed these practices, or where we find out whereabouts of the concept of insurance in India. In India, insurance is a legacy from the England, and has his historical roots in the ideas with regard to the Aryans, which are been there. For the first time, the practice of insurance in India can be traced back when the Aryans, almost 6,000 years back, they evolved the concept of the village and community life. The writings of Manu under the Manu Smriti and the Kautilya under the Arthashastra talked about the practice of insurances, talked about the practices of the insurance, which says that, and they mentioned that there was a concept of pooling of resources, which can be distributed in the times of the natural calamities like fire, famines, floods, and epidemics. And the term Yogashama, Varahama, that is means your welfare is our responsibility. Your welfare is our responsibility. It's been used for the first time by the Lord Krishna at the Kurukshetra when he was delivering his sermon to the Arjun. And this particular mentioning is being provided under the Rig Veda. which provides that the idea with regard to community insurance for the first time being practices when there was RNs there in the country. Before this, I give you an idea that there is also a slight inception of the insurance under the Islamic practices also, which is known as takaful, where there was a concept of blood money. What happened in that, how this concept is started in Islam. Concept of blood money, diya, which have given birth to the concept of insurance, which says that when a person of one kabila kills or causes any injury to the person of another kabila, now what is the protection ideology? So what happened that there were negotiation between the different kabilas or both the kabilas, where one person gets an injury and another person who has caused an injury to that person, they will decide upon the quantum of kettles to be decided upon that. They will say that certain amount of kettles you will give in amount of this certain causes which has been done by, or certain practices which has been done by that one person. Now that exchange of those practices, with regard to welfare of the public or the safeguarding the life of one individual for the purposes of returning of number of kettles with regard to that, which also propounds an idea of securing one's life, and that securing of one's life by one kabila for the pretext of providing the number of kettles or other things which are being decided might be possible. They can decide upon the amount of wheat, they can decide upon the amount of rice and everything with regard to that. So which also talks about that there is something which talks about the protection. And from there we derive the idea of insurance under the Islamic contexts. Now, moving towards with regard to the health insurance, why health insurance is a need of an hour right now. And especially in the times of pandemics, which the world is right now suffering in the form of novel coronavirus, as we all are aware about that, the social security is a concern of all the countries throughout the world. Every country wants to secure themselves socially, and there always remains a concern in the world at large. Although this dimension of social security differs from country to country depending upon their economic well-being. In some countries, you will find that the entire living expenses of elderly persons are being borne by the state itself. Those countries who are very advanced, they are bearing the expenses of the elderly persons who are been living there. And some states or in some countries, what they are doing, that they are taking care of the entire medical care of the elderly peoples in the country by providing them a social security measures. We don't have a culture which is right now prevailing in India, apart from the other countries, European countries. They have a different culture altogether. We have one of the best cultures in our country. We take care of our parents, or rather than there remains always a love and affection with regard to the relationship of children and parents. But the same does not happen in the other countries of the world. So they have to take care of all those things. So by providing this medical care, by taking the care of their expenses of the elderly people, this becomes an hallmark with regard to the social security at the world level. But if you look into the contexts, it is not possible for every country to do the same. Why it is not possible for every country to do the same is that they all don't have that economic stability which the other developed nations have right now. If you take into consideration the poorer countries of the world, they will not be able to provide such a facilities to the people, but they can do something which will be able to provide a platform for the purposes of providing social security at a world level, at the social security at their own level, and by providing health insurances at a lesser prices. They do, and they come into negotiation with the private companies who have been there or they are been running under their countries. They have come into picture with regard to the agreement that you should provide the insurances at a certain lower prices so that public at large can get the benefit of that, and they will be somehow able to solve the problems of the social security which are being there. Now, coming in India, there is a constitutional mechanism also under the directive principles of the state policy that in India, improvement in public health, that in India, the improvement in public health of the people of the country is a constitutional obligation. Improvement, I'm repeating it again, in India, improvement in public health of the people of the country is a constitutional obligation of the government as it is witnessed under the directive principles of the state policy under Article 38, 39, and 47 of the Constitution. This is something very important. Our directive has been issued under the Constitution to the state to take care of the public health, and they have to take all those measures which will help you in providing the improvements under the public health. And now it becomes more important for the government to come into picture to protect the health of the citizens against the hazardous and infection diseases in order to promote better standard of living, better standard of health care to the citizens of the country. The socially and economically marginal group, if you look into that, the socially and economically marginal group in the country are not in a position to handle the financial burdens that are being involved in the treatment of various diseases because they don't have such an amount of money. And what a best example we have right now in a contemporary scenario with regard to that COVID-19. If you look into that, right now the Indian government is providing a treatment free of cost to the people, all those people who have been suffering with this novel virus. And here comes an important point to note that those people who don't want to go to the government hospitals because of the lack of facilities, because of the lack of responsibilities, because of the lack of accountabilities, they want to go to the private hospitals where you will find a better treatment, better care, better facilities, better cleanliness with regard to that. Is it possible? Now a question comes to our mind. Is it possible that each and every one of us in India will be able to take the treatment under the private hospitals? I just give you an example. With regard to this COVID, if a person simply remains in isolation and a treatment goes for 10 days, if he has suffered from a coronavirus, minimum he has to pay 6 to 7 lakh rupees, which is not a small amount of money, which every person cannot bear in our country. And those persons who have that ability or those they have that power to bear those burdens, financial burdens, they definitely move to the private hospitals. They don't want to go themselves to the government hospitals because they say that we will not get those facilities which are being available under the private hospitals. We will not get those care and everything which we will get in the private hospital. But now, taking into consideration, there is between 30 to 35% of our population is not able to get a 3-day meal a day. In such a scenario, how you will be able to provide this facility to the people who are being there at a lower level, those people who are being at a marginal and socially backward, those people who are not financially capable of doing all those things. So here comes that how you will be making a balance between the private hospitals and the government hospitals treatment. And it's your obligation under the constitutions, under the directive principles of the state policy, that you have to take all those measures which are being there to promote better public health and to take care of public health in the country. I just give an example. Under a PM Care Fund, 100 crore rupees is being devoted for the purposes of the development of the vaccine for the prevention of the coronavirus. I am not aware about the situation when the vaccine will come up and how the government is going to distribute those vaccines to the different peoples who are being there. Why different peoples? I am using word that there are elderly peoples, there are peoples who are coronavirus, there are children, there are again again the young generation of the country, and those people who are suffering with the chronic diseases like diabetes, heart patients, they are being different, they are been suffering with the different. How you are going to make that possible, and how that distribution of that vaccine will be done? No doubt we have allocated 100 crore rupees for the purpose of development of vaccine, but where is that guarantee that each and every one of us will be able to get these vaccines, these all those things at a free of cost? And where is the guarantee that each and every one of us will get a better treatment under the government hospitals? Here comes the need. Here comes a requirement with regard to the intervention by the state for the purpose to ensure that the facilities which are being provided in terms of health to the maximum number of people, how we will be able to provide those facilities to the larger number of public, to the larger number of people. And we are able to do that. There is one scheme which is running right now, that for the poor people's Ayushman health card, for 5 lakh rupees, till the 5 lakh rupees, you will be able to get the treatment free of cost. Now, here comes a question. To what extent that is feasible? To what extent it is covering each and every individual? What is the tagline? What is the limit line with regard to that? Whether by this scheme you will be able to solve that? No. It is generally only one of the offshoots where the intervention of the state comes for the purposes of achieving the directive principles of the state, which is being given under the constitution of the country. Another thing, second option, which can be of a benefit to the public at large in times of the pandemics that we are being suffering, plus in the times of famines, plus in the times of the emergencies where we need to have that, government should regulate and promote. Government should regulate and promote and provide. I'm using three crucial words. Regulate, government should regulate, government should promote and provide health insurance to the large number of the people at a cheaper cost. Health insurance to the large number of the people at a cheaper cost. This is something you can do. What can be done? You can have a pool of companies who will be there. They are being able to provide this health insurance to the public at large at a cheaper prices. You can make a tailor-made policies in that with regard to the people who are being poor, where a premium, health insurance premium can be shared by the government as well as that individual. You can provide subsidies to these things so that you will be able to have a better and healthy India. We always talked about programs with regard to cleanliness. Yesterday, our Honorable Prime Minister had talked about a lot with regard to the cleanliness. He has provided awards to the cities which are being cleaned with regard to that, and the ranking has come up. Cleanliness, health and cleanliness goes together. Only providing Ayushman cards with regard to the amount of rupees 5 lakh. And I tell you, 5 lakh rupees is nothing. When you move to private hospitals in Delhi, within 2 or 3 days, they are going to say that now your 5 lakh rupees is over. Now you have to pay a cash. Because when you reach at the emergency levels, one day ICU and ventilator is costing near around 60,000-70,000 rupees. This is something different, plus room rent and everything, plus your treatment, plus your medicines and everything will nearly around there 3 or 4 days maximum it will survive. What will happen after that? What will happen after that? How the poor person will get those facilities which are to be needed? Then how you will be ensuring the principles of your social security that you have enshrined under the constitution, a grand norm of the country. So you have to take those measures with regard to providing health insurance to the public at large so that their standard of living will improve in terms of not only health. If they will remain well, healthy, definitely wealth will come. Health and wealth again goes together. They are the prefix and suffixes for the purposes of the development of the society. We need to have those things. Now a question comes with regard to that. What is health insurance? As many of us are aware about that health insurance is going on, I will be talking about health insurances now. What is health insurance? Health insurance is a personal insurance that provides the coverage for the cost of hospital and medical expenses arising out from the treatment of illness or injury or disease of a person, and it covers all the hospital expenses, critical illnesses, and disability benefits also. And in short, if I will say that health insurance provides a means to tackle, health insurance provides a means to tackle the problems related to rising medical expenses incurred by a person in the society. Or rather than it is a key to a middle class person or a poor person, if you have a health insurance, to get a better health facilities in the private hospitals, because all those rising costs of medication and medical facilities under the private hospitals cannot be borne by each and every Indian who has been here. So government has to take into consideration that how we will be able to do that. So this is one thing, this is one area where you will be able to sort this. Right now, if you look into that, I'm now coming to a pandemic of COVID-19. Government is providing you a free of cost hospitalization, everything in the hospital and everything. Have you ever looked into that? What we have lost for this? There is a hike, super hike in the prices of petrol and diesel in order to carve all those things. Government officials are not getting the full salaries. Their increments has been stopped. Plus, we have a beautiful gift of the coronavirus in the market in the form of price rise. Nobody is looking for this price rise. And everywhere there is a shortage of work, everywhere there is a shortage of employment. People who are working in the private sector are not getting the full amount of salary. How they will be able to survive? At least those people who have money, they are only surviving. Otherwise, the poor person has suffered a lot. Poor people have come out in the streets and they say that we want to die of coronavirus, no issue, but we don't want to die with regard to the not getting a food, not able to provide resources to our children. We are not getting any work. Talk about a poor rickshawala, he's a daily worker. If he is not able to run this rickshaw or to take his clients from one place to another, how he will feed his family? There are the certain problems which are been coming. Whether we are been looking to that, only providing 5 kg or 7 kg of wheat, rice and other facilities to the person will able to sort their problems. On context of what? We have a huge amount which has been now put it under a PM Care Fund. Whether that fund has to be utilized for the purposes, we get a ventilators and everything we have been getting. But coming to another aspect, why there cannot be a account settlements or account testings of that PM Care Fund, even though a few days before the Honorable Supreme Court has allowed it, that it's clear in crystal. But this is what the money of public at large, how this money has to be utilized in the senses. And on the second end, we have been providing money. Every public government employee is been providing a fund to the COVID-19 and to a PM Care Fund. But who will take care of those government employees or those peoples who are been suffering the price rise right now in the society? Plus, this has to go on for the next 1 year. Peoples are been taking fair advantage of the situations right now. So example is that you can only provide with regard to health insurance at a cheaper prices to the public. Suppose, take an example, I give an example. If someone has to take into consideration, that his entire family for 10 lakh rupees insurance, he has to pay a premium of rupees 14,000. Now I just give an idea that provide that insurance at 7,000 rupees, provide that insurance at 8,000 rupees, bear certain amount of money. The company will not take profits for the poor persons who have a income. You create a different slabs of income. The persons who are earning 5 lakh rupees per annum, persons who are earning 3 lakh rupees per annum, persons who are earning 10 lakh rupees per annum, and make this slab in such a manner, and the amount of subsidies to be paid for this purposes in such a manner, it will be depending upon that. As much as the small income group is there, the subsidy has to be larger in terms of health insurance. As much as the income group is higher, the subsidy has to be lower in that case. And at certain stages of income level, you should not provide any single subsidy to those peoples who are earning above 25 lakh rupees or 20 lakh rupees per annum. You have to take into consideration, because we have 4 classes of persons living in our society: higher class, middle class, lower class, and the fourth one is below poverty line class. We have to provide them a social security mechanism in terms of that, and the conditions like COVID-19 and the conditions like pandemics, then only we will be able to manage. Otherwise, we will not be able to manage the situations in such a manner, because manufacturers, producers with regard to essential commodities, they are taking the advantage of the situation. They are rising the price like anything with regard to that. We have never thought about the situation that a certain situation will come into picture. For that, we have to face, they have increased the prices for everything. And if you look into that, how this will be coped up, how this has to be coped up, how we will be able to provide a better treatment, how we will be able to provide resources to the public at large. Answer is only with regard to that, providing a health insurance. There becomes a need. There is an enormous need in the society right now with regard to health insurance, that government should intervene, government should interfere, government should sit with the companies, government should make policies, government should make planning with regard to that. And it has to be in such a manner that the benefit should reach to each and every one of us in the form of health insurance. Then only we will be able to thought about the process of pandemic. Plus now I'm coming to another aspect of this pandemic. When the vaccine will come in the country, who are the people who will get first? Will it not be the ministers? Will it not be the high class of the people? Will it not be the richest people of the country? Will it not be the people who are been in the very in a positions or jobs which are of a public nature, distribution with regard to that? Where will be the transparency? You have to take into consideration the transparency that has been needed. Then only the vaccination distribution will be done to the public at large. Otherwise, for the first 6 months or for the first 4 months, you will not be able to get the vaccine in the markets. And if you get the vaccine in the market, then it will be at such a price, it will be black marketed. The medicine wholesalers, the retailers will take the advantage of that, and they will sell it at a higher cost, which is above the cost of the actual vaccine. So still there is a time to manage all those things. Still there is a time to lay a guideline with regard to that. Speaking will not going to do anything. It is the work which has to be shown to the public at large. It is the thing that has to be shown to the public at large. Then only you will be able to have a better capability of handling the situations like pandemic in the society. Otherwise, it is not a win-win situation for everyone. You have a policy. We, as a law students, from a very beginning, since the inception of our law life, we listen that we have one of the best laws of the world, but we have one of the worst implementation processes. So here comes the issue again. Implementation has to be done in such a manner which will provide the better reliefs to the public at large. It should provide a relief in the segment with regard to the development of the society. Ultimately, if you develop a society, you will be able to develop the nation. For that, lot needed to be done, and health is one of the things which has to be taken care on priority with regard to every other thing. Health is one of the issues where you have to spend a lot of money. Hygiene is another important thing which has been associated, health and hygiene. Two things that has to be taken by the government. Don't provide subsidies anywhere else. Provide subsidies in the health sector, provide subsidies in the health segment, so that the country should not face problems of the treatment. The country should not face a problem with regard to better treatments available. You have to cater somewhere, you have to put an eye with regard to the plus. You have to put an eye over the price charges by the private hospitals. Where is the agencies which are been working? Why they are being charging so high? Why is the prices is not been down? I just give you an example. If you look into different kinds of insurances, and one more important topic which I have to discuss, when you have to take an insurance policy, so what are number one, medical expenses insurance. This is one of the kinds of a medical health insurance. Medical expenses. This insurance will only cover hospitalization charges and the cost of the doctors and all those being paid. Second kind of health insurance is long-term care insurance. In this kind, to a persons are covered. And the third one with regard to that is disability income insurance, which says that it tries to replace income that one will earn during the time of his disability. And the major objective of this insurance is to provide the loss of income to the person during his disability period or during the medication period. Now, these are the three kinds of health insurance. Plus, coming to another thing, Mediclaim scheme. This Mediclaim scheme is what I tell you with regard to that was framed by the General Insurance Corporation of India on 18 July 1986 with the approval of the central government. And because of this, I am telling you a more important thing here. Because of this, Section 80D was inserted under the Indian Income Tax Act of 1961, which gives you additional advantage on the deductions apart from the prime deductions of 1,50,000 rupees up to 20,000 rupees right now. I am talking about a contemporary scenario. In the beginning, it was started with 3,000 rupees. Now it is 20,000 rupees. Apart from 1,50,000 rupees, you will get a deductions of up to rupees 20,000 rupees. Suppose if you pay an income tax of 10%, then up to 20,000, it means that up to 20,000, it means that you will be getting a minimum of 2,000 rupees debit if you have a health insurance. If you have a 20% slab, you will get a 4,000 rupees deduction under the income tax. If you pay come under 30% income tax limit, then you will have a 6,000 rupees relief. And this income premium of health insurance varies from person to person, family to family, and all those things which are been there, and not up to the 20,000 rupees. It is lower down. If you take a minimum health insurance of 10 lakh rupees, though for 4 persons, the maximum premium will start from 12,000 rupees. Now, coming to another important thing for your practical purposes, precautions that are being needed to take at the time while you purchase a health policy. Suppose you have to purchase a health policy for yourself and your family. Directly don't purchase it. There are certain precautions which I am telling you with regard to that, because this is something very important. If you have not worked at the initial stages, then there will be a lot of problems that might cause to you. First of all, anyone who is contacting with you or you are contacting any of the health insurance companies, sit with that person and understand what are his policies, what he want to tell you, what policy will cover and what policy will not cover under that heads. Then after having a discussion with that person, discuss with at least 2 or 3 agents of different health insurance companies of the same sectors. Then you will be able to understand the pros and cons of different health insurance companies. Then the pros and cons and different policies. Definitely the other insurance agents of other health insurance company will tell you something which will be an added advantage to you. And then whatever be your queries with regard to health insurance, ask them fully, totality, ask them. And once you will get satisfied, then only you take the health insurance. Otherwise, don't take an insurance. Don't take an health insurance in a hasty or in a very prompt manner. At least give 3 to 4 days time to it, because you have to make a connection with at least 2 to 3 health insurance agents. Understand each and every company's policy. Otherwise you will be in a trouble, because anyone will come, he will talk to you about the very good things, and he will never talk about the undisclosed things which are being there. He will never talk about those things which are being not covered under the health insurance. I just give an example of this pandemic. Those people who have a health insurance, they are and has suffered a coronavirus. When they go to the private hospitals, what happened in that? they are being charged for 50,000 rupees for the PPE kits. And the insurance company says that, health insurance company, that these PPE kits are not being included under this. Now, just this is a simple example I am setting you. So many people have called me with regard to that who have a health insurance, and they are been asking me why it is not been included. Now, what has happened? At the time when you have purchased the health insurance policy, first of all, we people are not aware about there should be a corona. But every health insurance policies have options available. What is option? That you want to include each and everything, each and every expenses inside and outside with regard to the treatment. In that case, the premium will be little high. Then in comparison to that, you will not be adding those things which are being not used for the medication purposes. Companies have outrightly rejected the concept of PPE to be included under the insurance cost. Why? Because they get a benefit here, they are using an advantage. But at the time when you have asked your insurance agent with regard to that whether each and everything will be included or not, I want that health insurance which include each and everything. If you are being providing me with that insurance, then only I will take insurance, otherwise I will not take insurance. So make it clear, crystal clear with your insurance agent that whatever you are been demanding, he's been providing to you, and ask him very clearly whether it is of a higher cost premium, we are ready to pay a premium in a higher manner. But taking lower premium will not allow you to take the advantage fully. Right now, if you take into a consideration, certain health insurance companies are including ambulance charges also. Suppose I am sitting right now in Aligarh and the best private hospitals are not available, we have to go to the Delhi. Now from Aligarh to Delhi, if I go by a medical emergency or ambulance, that cost is also to be included. Clearly ask your health insurance agent at that time whether it will be included or not. I need a health insurance policy which will include each and everything for the purposes of treatment from my house to the hospital. Because if that has not been included, then you will not be able to taste the real benefits of the health insurance. And there is only a slight change of premium when you are asking from everything from your home to the hospital and outside the hospital. And that insurance starts from the hospital. There are little bit, only 1,000 or 1,500 rupees insurance premium will be a difference. But this difference, when you suffered, cost a lot. So my humble advice to every one of you, while you purchase a health insurance, and this pandemic has taught us that we must have a health insurance. We must take a health insurance, those who have a capacities, and I have already provided, government should plan and government should provide a subsidy to the health insurance to the different class of people in a different manners, different slabs can be made, because you cannot be equal with regard to equal different level of group of peoples who have a different level of incomes also. We cannot compare Mukesh Ambani with the person, with the beggar who has been sitting outside the road on any city, because there is a differentiation between Mukesh Ambani is the 6th richest person of the world and he is one of the poorest persons of that particular district, don't have a 3-time meal. So there has to be providing of subsidies at a different level of groups, and it has to be demarcated in a different manner. Plus another important thing, that why we are not able to have the fruits of the insurance tested yet. Why we are not able to test it properly? Because what happened in India, still a large number of people don't have a health insurance because there is a lot of poverty. We are conservative, illiteracy has been there, and there are so many facts which does not appeal the public at large that the benefits are being there. They don't have that enthusiasm which has been available for the purposes of taking health insurances. So what can be hoped for is that we can provoke public at large for the purpose of health insurance who can take, plus the government should definitely intervene, witnessing this present situation, that they should make up policies in such a manner. Ayushman health card is not going to solve the problem for a longer run. You have to make insurance, health insurance at a cheaper cost. You have to provide it to the public at large as a cheaper cost. then only the options of social security plus the conditions that we are being suffering right now. The world is suffering right now, the pandemics. And if God forbid us, if another pandemic will come up, then what will be the situation of the economy if we don't have that health insurances? So subsidies should be provided to it. Then only the things will come into picture, which will help the society at large. And definitely, I can say that, and this is one thing, that health insurance is a need of an hour in the present scenario. Thank you very much. Now you can ask the questions with regard to that. Whatever I have to say, I have talked about that. Yes.
Thank you so much, sir. Thank you so much for covering the important aspects of health insurance, especially during the time of pandemic. Now the floor is open for questions. So if anyone has any question, you can just type in the chat box or unmute your mic and you can ask the question directly. So, sir, okay, we can wait until then. Sir, I have one question.
Yeah, sure.
Yes, which I mentioned yesterday when we were talking. Like, SAU has given us insurance of 1.5 lakh to each and every student. And recently we got a notice that this health insurance is applicable only if you have been admitted to 48 hours or more in a hospital. So such kind of clauses are allowed to insert in a health insurance which has already been given. I mean, can you amend the health insurance? Because most of the time these insurance are implied contracts. So is it allowed or is it illegal?
What happened in that, there are corporations, there are companies, there are different entities who provide health insurance to their workers. In the same manner, the South Asian University is providing a health insurance to you. In this case, what happened, they used tailor-made policies. This tailor-made policies, what I tell you, they will provide their terms and conditions, and the company which is providing health insurance will make the policy in the requirements what the enterprise has been asking for. So tailor-made policies, but the thing is that tailor-made policies are only allowed under the organizations, under the different entities, under the universities like you people, but it has not been allowed for a general class of people or in a general insurance when you take individually. Individually, whatever you will take, then they will not go for a tailor-made policies. Tailor-made policies are only made for organizations. So it is totally applicable for you. And SAU can put a condition like that.
Thank you, sir. I think, sir, we have a question. Avantika, can you please unmute your mic and ask?
Yes, sir. Actually, I wanted to ask that recently, like we have a health insurance for our entire family, but unfortunately, in the last 3 years, my father has been admitted in the hospital twice, and he has had like severe accidents. On one occasion, on both the occasions, the insurance company have been, they have given the entire, they have paid the entire amount. But after paying the second insurance, like giving away the in the second instance, like giving away the money, they themselves canceled the insurance and said that my father is not liable to any more insurance coverage from that company without giving any particular reason. From like after that, we have tried to email the insurance company and the other bodies also. I want to ask, if something like this happens, like unjustified cancellation of insurance, what is the remedy that we have?
Okay, very good question. It also happens 2 years back with one of my friends when he asked it, and you have asked the same thing which he has asked and he has suffered. There is one Insurance Regulation Development Authority of India, IRDA. They have their toll-free numbers for the purposes of lodging complaints. Plus, they have their complaint IDs, a grievance redressal cell. They definitely take care of this. You just write an email to them. Only one thing that you have to do is that your premium has been paid for that period of time. Your insurance should not lapse. Your insurance, if left, before the lapsing of insurance, you should complain to the IRDA. Then only the things will take into consideration. If your insurance will lapse, after that you go for that, then in that case, IRDA is not going to help you. And if your renewal of insurance is not being done by the company and you are being ready for the insurance renewal, in that case also you can complain to the IRDA with regard to all those evidences that you have. Write your complaint. They have a format. You can go to the IRDA's website where you will find a grievance redressal form. In that form, you put it your grievances and just mail that form within 2 days, maximum within 48 hours. They say that you will get a complaint number ID. And I tell you, IRDA definitely takes care of that. And in the same case, my friend case, which I was referring you, IRDA has ordered the company to take care of the insurance and cannot say that until and unless the client does not want to carry on the insurance, company cannot refuse if he has already done insurance. Hopefully I answered your question.
Thank you, sir. Thank you so much.
You just go to the IRDA website with that.
So I think we have 2 more questions. One is from Rida and another is from Venu. So Rida, can you ask your question if you can unmute? Right.
Hello, good afternoon, sir.
Good afternoon.
So my question is that we have seen that in this pandemic situation, like when the lockdown took place, that we have seen that there's a suspension of most of the usual economic activities. Like we have seen the huge section of population, they have lost their livelihoods and they are facing tremendous economic instability. So yes, you have told that the government should provide the free insurance, cheap insurance facilities. So what other measures do you think that government should take the government should take to tackle with this issue?
Okay. 2 things that I have talked about in my discourses in the lecture itself. Number 1 thing, that government should provide health insurance to everyone at a cheaper cost and subsidies with regard to the different level of income, because we cannot provide each and everyone the same amount of subsidies. It has to be differentiated with regard to the income group. Second thing, I was talking about vaccination. When the vaccine will come with regard to pandemic, with regard to this corona, the transparency should be there with regard to the distribution. There should not be a distinction between have and have nots. There should not be a distinction between rich and the poor. It should be with regard to your priorities. Number 1, corona warriors. Number 2, the chronic patients. Number 3, whatever be your priority. It should be transparently distributed. Then only you will be able to handle the situation. Otherwise, the situation is not going to handle, because those people who have resource, they will take the vaccines. You should also take an eye that there should not be a black marketing of this. I just give an example in Delhi and what is happening. Remdesivir medicine that has to be used for the purpose of cure of corona cost only 4,800 rupees. And that is being sold at 25,000, 20,000, 30,000, 40,000 as per the need of the person. What a person will do? Marta kya na karta wala condition is they have to buy it at a higher prices. Where is the mechanism of the government? Where the teams who have been there, they are not looking for that purpose. This has to be stopped. This has to be regulated. Then only the treatment will be reached to the public at large, and ultimately you will be able to handle this pandemic by providing resources to available to each and everyone. I just give an example of America. America has purchased the entire lot of remdesivir manufacturing of July, August, and September for their citizens, because they have the money. They have a huge amount of money to be spent on that, and already they have contracted with 3 vaccine manufacturers, AstraZeneca plus Moderna they have, and plus Johnson & Johnson. They have purchased more than vials, more than their public. That's only because they are the superpowers, they are more developed, they have a money. And recently, if you look into that WHO wants to sign a treaty, COVAX, where the distribution of vaccine to be done in a free and fair manner, in a transparent manner, so that it should reach to the poor countries also. I hope I am able to satisfy your question.
Yes, sir. Thank you, sir.
I think Venu would you like to ask question also? Okay. So the question is, why can't states include COVID treatment with respective health insurance provided by the government? If need, include Yes.
Kindly repeat a question. I don't able to get.
So you can also see in the chat. It is the last.
You just speak because I have to move into the chat.
So the
box.
question is, why can't state include COVID treatment with respective health insurance provided by government?
Okay,
If
okay.
it include how citizen or people from legal departments to happen. So
Okay, okay.
yes, sir.
Obviously, I just give you when you have arrived, asked a very good question. Right now, if you look into that, IRDA has issued a guidelines in the April month itself. All the health insurance companies, even those don't have include the treatment of the COVID-19, they have to include the treatment of COVID-19 in it, and they cannot say that that is certain clause was not being added in the health insurance policy, so they will not provide the benefit to their clients. Irrespective of everything, IRDA overrides this and says that each and every health insurance company has to take into consideration the treatment of COVID-19, and they have to provide a money for the purposes of that. Now, this is one aspect of your question. Now, coming to another aspect, that state. Yes, definitely. What is being done by RDA is that they have started a special coronavirus in health insurance for rupees 256 only per annum, in which anyone can purchase that health insurance. It is being provided by the LIC as well as it is being provided by the other health insurance companies. It is only at 256 rupees per individual, not family. It's 256 rupees per individual for an entire year. So under 256 rupees, you can save yourself from a coronavirus treatment of 7 lakh rupees, still a treatment of 7 lakh rupees. So it is some subsidized health insurance which is issued by the IRDA, taking into consideration with regard to handling of this pandemic in the country.
Thank you, sir. Thank you so much. I have venue has answered well. So with this, we don't have any more questions, sir. So thank you so much once again for joining us for this our first virtual summer school, and I hope all the participants have been benefited in terms of insurance law, because we rarely get to be taught in graduation. Not all the law schools teach insurance laws. So most of our participants are undergraduate students. So I think it was really good. Thank you once again, sir.
I thank you also, because you have started a great initiative and provide me a chance to speak on this topic. Hopefully, I am able to sort out certain things, not in a totality, because you can't do much more within 40 minutes. You have to keep into consideration the time element also. And if anyone has any issues, can definitely ask me. I have an insurance book written, and that is being published by the LexisNexis. And right now I am again revising it with regard to the new things which has to come in. And anyone can drop me an email with regard to asking any of the queries. I'm always open to all of you. And thank you so much. And God bless you all. Thank you.
Thank you. Thank you.
Thank you.
So we will send email this to the participants so that they might ask questions if they have.
Yeah, you can definitely send, and you can also send my WhatsApp number if they have any issues. I'm always there. Don't worry.
All right.
No issues.
Thank you so much.
Thank you. Thank you so much. Thank you so much.
Have a good day.
Thank you.
So before we wrap up this summer school, I have few important announcement to make. First is that we have one speaker. We had one speaker, Dr. Sergey Saipin from KAMEP University, Kazakhstan, who could not join us. So we are in touch with him. Whenever he gets the time to speak, he will join at the first opportunity. But apart from him, we are also in touch with few other scholars. So one scholar is Dr. Surya Deva. He is associate professor at City University of Hong Kong. So most probably he will join next week on weekends, maybe Saturday or Sunday. We have proposed date of 29th of August for him to speak on. He is a scholar of business and human rights, and he is also member of United Nations Working Group on business and human rights. So this was the first ever group of business and human rights at the UN. So I hope you all will be benefited. But apart from Surya Deva sir and Dr. Sergey, we are also trying to contact Dr. Anirudh Singh Rajput. He was the member from India in the International Law Commission. So we have 3 important people to join in next coming weeks. And we request all of you to join those sessions. We will send the Zoom link, and those sessions will be conducted in terms of webinar. So all those who will join get a separate certificate of webinar free of cost. So all the sessions that are coming this month and next month in September, one day there will be only one session of 1 hour, not more than 1 hour, right? So we welcome you all to join all those sessions, and I hope this Dr. Sarji's session will be compensated well, and maybe Dr. Sarji himself will join because he has prepared his lecture and PPT also. He will join as soon as he gets the time, right? So apart from the upcoming session, on this assignment and feedback, see, we request you, if it is possible for you, to write one assignment in the format of a blog of 700 to 1500 words, right? And put hyperlinks. We will send the detailed guidelines for this, because if it is a format of blog, we will try our level best to publish it on blog. So as earlier said, we want you to write in terms of blog so that we can publish it. That will be beneficial for you also, so that you have one publication somewhere, right? But if you don't have much time for writing a blog, you can just write a 500 words summary. You can just write a summary of what you learned, or how the COVID-19 has, what is the legal response to the COVID-19 on any specific or broader topic. There is no problem, right? So apart from that, the time for submission of I think 1 week will be enough. But if anyone has a specific request that he should be given more time, more than 1 week, you are most welcome. So we are having a difficult time of coronavirus, so we can give more than 1 week. But if you send within 1 week, we would like to distribute a certificate as soon as possible. So let's say if any participant is submitting his assignment by tomorrow, we will be able to send his certificate by day after tomorrow, right? So those who submit early will get certificate as early as possible. We have already started making your certificate, so it will not take much time for us to distribute the certificate, right? So if there is any other question, and yes, as far as the materials of this the whole summer course is concerned, we will send a separate material, separate Google Drive link, because I think last night which we sent the link, that was not open for all, and we got several requests for access. So I'm really sorry for that. So we will collect all the study material and put it in a Google Drive folder, and we'll resend to you all, right? So that is one thing. So if there is any other specific question, so please feel free to ask. All right, so I think we don't have any question. So thank you so much, all of you. Okay. Where to submit? Yes, Rachna, actually, we will send you an email, and there will be a Google form. So you can submit your submission through that Google form, because that will consist also the feedback form. So feedback form is not much longer. It is only 3 to 5 questions are there in this feedback form. And you can submit your writing in that particular feedback form where the option is available. Any other question? So thank you everyone. If there is no question, and submit as soon as possible, so that, because we also want to relax by distributing the certificate, because that will and that is itself a work. So we don't want to keep it longer, right? So we will not make you wait for the certificate. So thank you once again, and have a good day.